Family conflicts and missing heirs can completely destroy an inherited property sale. Selling an inherited property can be challenging even with the most close-knit families. Between the multiple beneficiaries, all the decision-making, and the legal documents, these challenges are magnified with beneficiaries that are estranged, incarcerated, missing, or just otherwise difficult to get involved. My name is Carolyn Castillo with Probate Property Angels. I have overcome these exact scenarios for my clients. And in this video, I'm going to give you my top 3 tips on how to avoid these roadblocks. Let's go ahead and dive in. So my number 1 tip is if you are aware that you have a family member that's either missing or not willing to participate or has been estranged from the family for a long period of time. I've had many different families over the years. Some of them have had a brother or sister that was incarcerated. They've been incarcerated for like 10 years. I had a case recently this year where a sister had been missing for over 5 years. The family hadn't known, her whereabouts were unknown. I've had other heirs, other families where a particular brother was estranged from the family, very little communication to the other heirs. So even before this situation, it was already difficult to communicate with them. So if you're in a family where you have that type of situation going on, the number 1 thing that you want to do to avoid problems, and I'm telling you, these are big problems. These are the things that will completely stop you from being able to move forward and sell the property, from you being able to move forward and do a lot of things. Because when you're inheriting a property, all the beneficiaries have to be involved. All the beneficiaries have to make decisions. All the beneficiaries have to sign documents. So what is a family to do when they know that there's an heir that they will not participate, or you don't know if they will participate? My number 1 tip is to file a formal administration. So when you have to go to probate and you meet with probate attorneys, you're going to have 2 options: to file a summary administration or file a formal administration. Now, typically, if the estate doesn't have a lot of assets, in fact, the law reads that if the estate has $75,000 or less assets, okay, then that estate should file a summary administration, which is a very simple administration that basically just transfers the assets from the deceased name over into the heirs' names, okay? The problem is with this administration is that there is no formal appointment of a personal representative. Now, sometimes in some wills, they will appoint a personal representative in the will, okay? But if your family member did pass away without a will, or if the will doesn't specifically appoint a personal representative, then your family wants to set up the formal administration. Because the formal administration, you can be appointed as the personal representative for the estate. When you're appointed as the personal representative of the estate, it is now your duty to administer the estate on behalf of all the beneficiaries, okay? So that means that you would be able to go ahead and get the authorization to sell the inherited property, okay, by you signing as the personal representative. That's what your duties are, is to sell, lease, or mortgage the real estate, whatever is in the best interest of the estate, okay? You would be able to go ahead and get court authorization to sell the inherited property as the personal representative of the estate. Now, when you do that, what basically is happening is you're selling the asset. The monies are then being distributed to an attorney's escrow account, or if you've set up an estate account, it would go into the estate account, okay? Now, why is that such a big deal? Because we would not need the other beneficiaries and the other heirs in the family to sign on behalf of selling the property. The monies will get deposited into the attorney's estate account, and you will continue to do your due diligence in locating the missing heir, the estranged heir, the difficult heir. You will show the court that you've done a due diligence. If that family member cannot be found, has refused to respond, has refused to be a part of the estate, then the attorney will file a petition to the court showing that you had made diligent effort to reach out to this person, to make contact with this person, and were unsuccessful. At that point, the judge will then put the distribution for that heir. They don't lose out on their inheritance. Their inheritance is still secure. What the court will do is they'll take their inheritance and they will put it in a court-registered account so that whenever they want to arrive and they want to come forward, the monies will be waiting for them in the court registry. Okay? This is my number one tip. Now, you may be watching this video and saying, dang, I wish I would have watched this video prior because I already filed a summary administration. I already filed for probate. A lot of people go for the summary administration because it's cheaper and it's supposed to be a quicker process. But the part that a lot of times the attorneys leave out is that it gives you almost no power. So when you're in the summary administration, it's literally transferring the assets from the deceased name over into the beneficiaries' names. However, if the beneficiaries are not cooperating or you can't find the beneficiaries, then this is where you get into a humongous gridlock in your probate and your inheritance, okay? So my number one tip is to file for the formal administration. Now, my number two tip, which you filed whatever you filed. You didn't watch this video before you opened your probate and you are where you are and now you're stuck because you can't find the heir, they're not cooperating. What we recommend is hiring third-party communication, okay? Now, in the case where the heir is completely missing and nobody has any wherewithal of where they are, that is we would have to skip onto the third tip that I'm going to share with you. But if we're talking about a disgruntled heir, we're talking about an uncooperative heir, we're talking about someone that's incarcerated, okay? We're talking about somebody that doesn't want to participate with the family. We have found great success in third-party communication. So here at Probate Property Angels, we assist the family in reaching out to all the heirs in the transaction, in the estates, okay? Now, unlike other real estate transactions where there's only one seller, when you're selling an inherited property, there's multiple sellers. There could be, the most I've ever had is 13 sellers, okay? So imagine 13 people that you need to get on the same page, that you need to make the same decision, that you need to sign the closing documents. It can be quite the experience. So what we recommend is third-party communication, like a company like myself. Now, some law offices do offer this, but to be honest, the attorneys are not typically going to be chasing after these heirs, calling them, emailing them, texting them, making the attempts to reach out to them over and over and over and over again. We've had some cases where we've had to make 10, 15 attempts in reaching an heir, maybe by visiting their property, by mailing them a letter, by sending them a text, by having a private investigator go over to the property, meet them in person. There's a lot of things that we can do civilly to try to reach out to these people. I've had a lot of success with heir just not getting along and not wanting to speak with each other. And then I'll say, well, if I can speak, with your brother or sister and I can communicate with them and get everything, would you be willing to move forward? Yes, I'll move forward, but I don't want nothing to do with my sister. Okay, not a problem. And then we will basically work the transaction, being the middleman in between the family, the brother and the sister, or whoever it may be, okay? So the number one tip is file the formal administration. The number two tip is to hire third-party communication. Now, I have had a lot of experience helping executors in these exact scenarios. All family dynamics are different, and that's why I offer free phone consultations to discuss your family's specific case. So set up a call today with me. It's a free consultation and we'll go over your case. Now, my third and final tip is the one that I like the least, but I have had to use it in a handful of cases. And this is where you have to file a partition action. Now, when you inherit a property, it is not acceptable option that you cannot bring your family together. You cannot find everybody. You cannot get everybody to agree. So I guess we can't do anything. I guess we can't move forward. No, that's not the case. So when the family is in this predicament, you will file what's called a partition action. This is basically going to petition the court to let the court know that there is disagreements that can't be figured out harmoniously, or there's missing heirs, or there's people that are not responding. So what the judge will do is they will request their appearance to come into court. It works just like any other court proceeding. You will get filed a motion for you to appear in court. If you do not appear in court or you do not respond to the motion, then the partition will move forward accordingly. And the way that the partition would move forward would be the same way that the formal administration would work, the first tip that I gave you. The judge will go ahead and approve the authorization of the sale and will take that heir's portion of the inheritance and will put it in a secured court registry account. So whenever they decide to come forward, their money will be there from the inheritance. Now, if the missing heir or the disgruntled heir comes forward and they are at the court hearing, basically the way that these go down is the judge says the court has ordered the affirmative order to sell this property. Do you have the means to buy the property? The person more than likely is going to say, no, I don't have the means. Or they say, yes, I do have the means. And at that point, the court would order them to complete the sale and pay off the other heirs. If they come out and say, no, I don't have the means to purchase this property, then the judge will order an affirmative order to go ahead and push the sale forward, okay? So it's very important to know that you have options, and when you know your options, your family can move forward and your family can get past this scenario. I hope that this helped you, and if you want more tips, visit our website at www.probatepropertyangels.com and download our free executor guide where we go in great detail on this exact topic.